On paper, Florida law blocks Chinese nationals from buying property in the state. Whether it actually applies to you, though, depends on something the law never bothered to define clearly: where you intend to live. That question turns on a legal concept called domicile, and it is what ultimately decided the case. That is not a legal theory someone invented in a courtroom argument. That is the conclusion a federal appeals court reached in November 2025, in a ruling written by Circuit Judge Robert Luck. Florida Senate Bill 264 cleared Governor Ron DeSantis' desk on May 8, 2023, and took effect on July 1st of that year. The stated purpose was direct enough. It barred foreign principals from countries of concern, a list covering China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria, from acquiring agricultural land in Florida, from holding real property within 10 miles of any military installation or critical infrastructure, and specifically targeting Chinese nationals who are not citizens or lawful permanent residents, from purchasing any interest in real property anywhere in the state at all. When DeSantis signed the bill, he said it would help protect Americans from the influence of the Chinese Communist Party. That was the stated intent. The legal reality came apart almost immediately. The law does contain an exception, and this is the part most people focused on. Chinese nationals holding a valid non-tourist visa, categories that include H-1B, F-1, and L-1 holders among others, or those who received asylum, can own one residential property of up to 2 acres, as long as it sits more than 5 miles from a military base. They also have to register it with the state, and failure to do so runs to $1,000 per day until the disclosure goes through. That provision got labeled the loophole, but it is really just the visible edge of something deeper. 4 Chinese citizens living in Florida filed suit almost straight away, and the case became known as Shen versus Simpson. The ACLU of Florida and the Asian American Legal Defense and Education Fund served as counsel for the plaintiffs, who argued the law echoed alien land laws that stripped Asian Americans of property rights across the country a century ago, including California's Alien Land Law of 1913 and the wave of similar statutes that followed in the 1920s. Bethany Lee, executive director of AALDEF, stated the law told generations of Asian Americans this country was not their home. A federal district judge denied the request to block the law in August 2023. But then, in February 2024, a unanimous 11th Circuit panel granted a preliminary injunction blocking enforcement against 2 of the 4 plaintiffs while the appeal continued. That ruling turned on something small, and the smallness of it is the point. Both plaintiffs, subject to the injunction, had lived in Florida for years and intended to stay. Under long-standing legal principles that predate the United States itself, a person who resides in a state indefinitely, regardless of what kind of visa they carry, can be considered domiciled there, and the court found the law as written applies to Chinese nationals domiciled in a foreign country, not to those domiciled in Florida, which meant a Chinese national who had lived in Orlando for a decade, who paid Florida taxes and sent children to Florida schools, might fall entirely outside the reach of the statute written specifically to restrict their ability to buy property there. Now forget the 2-acre residential exception for a moment, because here is what the court actually resolved. In November 2025, a different 11th Circuit panel issued its final ruling in a 2-to-1 decision, with Circuit Judge Robert Luck writing for the majority. The court acknowledged that national security, food security, and land security concerns motivated the law's passage, and it allowed Senate Bill 264 to remain in effect. What it did not do was uphold the law on its merits. 3 of the 4 plaintiffs, the court found, lacked standing to challenge the purchase restriction at all because under the domicile analysis, the restrictions simply did not reach them. The constitutional questions everyone expected the court to answer, whether the law runs afoul of the Equal Protection Clause, the Fair Housing Act, or Federal Investment Review Authority under bodies like CFIUS, the Committee on Foreign Investment in the United States, went untouched. After the ruling came down, the plaintiffs voluntarily dismissed their remaining claims, and the case closed without a single finding on whether Senate Bill 264 is constitutional. The result is a law that is technically enforceable and constitutionally untested at the same time. Florida's is both of those things today. The broader picture of Chinese-linked land ownership in the United States carries its own caveats, and they matter for understanding what is actually being measured. According to the USDA's most recent AFIDA annual report, covering holdings as of December 31, 2024, foreign investors collectively held interests in over 46 million acres of American agricultural land, which works out to 3.6% of all privately held agricultural land in the country. Chinese-linked holdings, per that same report, accounted for roughly 0.5% of the total foreign-held acreage, and the 5 largest Chinese-linked companies alone accounted for 92% of all reported Chinese agricultural land holdings. One of those companies is Murphy Brown, LLC, a subsidiary of Smithfield Foods, which a Chinese meat company, WH Group, acquired in 2013. These are figures for agricultural land. No verified statewide aggregate for Chinese-owned non-agricultural Florida real estate appeared in the available public record, so those two categories should not be treated as the same thing. And the AFIDA numbers themselves deserve some scrutiny before anyone treats them as a clean total. USDA reporting under AFIDA is self-reported, subject to reclassification between annual cycles, and the figures include long-term leases and partial stakes alongside outright ownership. Both the USDA and the Government Accountability Office have flagged weaknesses in how the underlying data gets collected and verified. What the numbers show is reported holdings, not a comprehensive audited registry of who owns what. More than 30 states have now passed or introduced bills restricting foreign property ownership. Texas Senate Bill 17, Arkansas, and Oklahoma are among the states that have assembled their own versions of this legal architecture, and the framework Florida built in 2023 has become a reference point for legislators elsewhere, gaps included. The mechanism at the center of Shen versus Simpson was not a sophisticated financial structure or a network of shell entities. It was the ordinary legal concept of domicile, something any first-year law student encounters in a conflicts of law course, and it was enough to exempt several plaintiffs from a statewide property restriction without anyone needing to find a clever workaround. Ashley Gorski of the ACLU, responding to the November 2025 ruling, said the fight against laws targeting immigrants based on national origin and ethnicity would continue, even with that particular case now closed. The constitutional questions the 11th Circuit declined to answer are not going anywhere. The pattern here, a law that appears sweeping on its face but rests on a threshold condition courts are still working through, repeats across the foreign ownership space in different forms, different states, different asset classes. Tracking who owns America, one record at a time, is what this channel does, and the next one is already in research.